So yesterday, the Gwyneth Paltrow ski accident trial started, and it was an interesting opening day. I'll have more on that in just a moment down at the beach. When I got ready to try my first case all by myself, which interestingly enough was a criminal case, I worked for hours on my opening statement. I worked very hard to make sure I didn't have any argument in the statement, that I stuck to the facts, and that I told the jury what the evidence would be from the defendant's point of view. When I made my first plaintiff's opening statement, I did much the same. I worked for hours. I rehearsed. I had everything down. I had timing. I had slides. I worked and I practiced and I made certain that I knew that case as well as anyone. And I came in and did my opening statement, and it was very, very good. The judge told me that later on. Same thing with my closing argument. He said it was one of the best he'd ever heard. The bottom line is, when you get ready to try a case as a lawyer, you have to be ready. You have to know the case inside and out, and you have to be able to tell a story. And if you go and pull any of the opening statement by the lawyer who represented the plaintiff in that case, Mr. Anderson, and listen to just 3 to 4 minutes of that argument, I believe what you'll find is a guy who came off as disjointed to me. Now, you may think he did a great job. I don't know. And if you do, please leave that in the comments. I would love to hear from you on that question. How do you think he did? Way and the pacing and the way he kept turning and moving back and forth. He wasn't using visual aids. He was recounting testimony in a way that was a little bit suspicious to me. In an opening statement, when you tell the jury what the evidence is going to be, you can say, we have a witness who will testify that this happened. But what you don't do is quote them, and especially when that comes close to violating a motion in limine. And I think that's what happened yesterday with this idea that a witness said that Ms. Paltrow bolted. And there had been a motion in limine, as I understand it, to prevent anyone from saying that this was a hit and run. But that was very clearly what the intent of that statement was. And it drew an objection and all of that. The bottom line is, if this had been a trial advocacy opening statement in law school, I would have given this person probably a C-. They got, I think, all of the points that they needed to get to set up a good opening statement, but they did it in a way that was difficult to listen to. Contrast that with the defense attorney in this case. And I want to make a point here of saying that, I was a plaintiff's attorney. I tried plaintiff's cases. I also defended a couple of cases. And when you do an opening statement for the defendant, you don't have to say a lot. The only thing you absolutely have to say is, it wasn't our dog. It didn't bite you. If it did bite you, you didn't get hurt. And what are you complaining about anyway? You're not really hurt. These are the things that you do in sort of an offhanded way, and you indicate to the jury, there's no there. I thought the defense attorney did a much better job in his opening statement than did the plaintiff's attorney. That's based on having watched numerous trials, and I think I'm right on this. But we'll have to see when the time comes. One of the things that he did that I thought was absolutely brilliant, the defense attorney, was he said, look, you don't have to find that anyone is at fault. You can find that no one is in fault, because there are inherent risks in skiing. And that's absolutely true. There are definitely inherent risks in skiing. The first time that I ever went skiing, I took lessons, And our instructor told us that if you get out of control, then you just sit down on your skis and roll off. Well, one of the people who was in our party, the skis got away from her, and she got that half right. She sat down on her skis, and of course that lowered the wind resistance, and now she is a rocket sled on rails heading toward the mountain, toward the bottom of the mountain. Finally, she did remember to roll off the skis, and it looked like that scene some of you may have seen from the wide world of sports where the skis go flying, and that's pretty much what happened. But there are inherent risks. It's very easy to suffer an orthopedic injury, a head injury. It's very easy to wind up getting yourself killed. Ask Sonny Bono. Oh, wait, you can't. Anyway, the bottom line is, I thought that the opening statements went much better for the defense than they did for the plaintiff. And I thought the cross-examination that was done by the defense of one of the first witnesses that was put up was also very well done by the defense. The direct was also well done. I have no complaints about that. But I do think that the cross-examination was probably a little bit better than was the direct examination. So with that little bit of analysis, I would encourage anybody who's interested. Law Nerd Clips, we'll have little clips of this during the day if you don't want to watch the whole video. It's on both Law and Crime and Court TV's channel. I'm sure that there are a number of legal streamers out there who are watching this trial and streaming it and commenting on it. I don't do that because I have a real job and I don't have the time to do that. But I think it's interesting from my perspective that service is out there if you want to partake of it. Frankly, I find people talking over the witnesses and the lawyers when the trial is going on to be more than a little bit off-putting. So with that, if you have any questions, leave them in the comments down below. Like, share, subscribe, all the stuff we ask you to do. Thank you so much for watching, and I'll catch you on here next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.